Okay. Do you want to say something?
Yes. Ladies and gentlemen, welcome to this hearing. Judge Paul Wilson, I'll be presiding. My apologies for the technical difficulties, but we think we've solved them. Is anyone having trouble? Oh, let me turn the, yeah, let me do that. I just turned my air conditioner off so I can hear you. Is there anyone who's having on the screen here in the Zoom call who's having trouble hearing me?
No, Your Honor.
No, I can hear you loud and clear.
All good over here as well.
Okay, great. I'm going to ask Mr. Walsh, the clerk, who you can see is a black box on the screen, to call the case, and then he'll ask counsel to introduce themselves. As you know, the ground rules I've set are that we're going to have one lawyer arguing for each of the two parties and the one enhanced amicus, unless the lawyers convince me that some other way of handling the matter should be done instead. So, Mr. Walsh, if you'll just call the case.
Good morning, Your Honor. Thanks for waiting. The case of Mitchell Matorin and Linda Smith versus the Executive Office of Housing and Economic Development in the Commonwealth of Massachusetts. The docket is 21334. Would you please, for the record, introduce yourself to Judge Wilson?
Good morning, Your
Good morning.
Honor. Good morning. I'm Jennifer Graney. I'm an Assistant Attorney General, and I'm representing the Commonwealth and the Executive Office of Housing and Economic Development.
Good afternoon, Your Honor. Good afternoon. Good morning, Your Honor. My name is Richard Vetstein. I represent the two plaintiffs in this action, and with me is Jordana Greenman, who will introduce herself.
All right.
Good morning, Your Honor. I'm Jordana Greenman, representing the plaintiffs as well. Thank you.
Good morning, Your Honor. Joey Mikalakis on behalf of City Life Vita Urbana, Chelsea Collaborative, Lynn United for Change, and Springfield No One Leaves.
All right. And you have some lawyers with you as well who also signed your amicus petition and ultimately your amicus brief. I'll let them introduce themselves.
Morning, Your Honor. My name is Andrea Park. I'm at the Massachusetts Law Reform Institute for the proposed intervener enhanced amici.
Good morning, Your Honor. Jane Edmonstone with Community Legal Aid on behalf of the enhanced amici.
You.
Good morning, Your Honor. Maureen St. Cyr from Community Legal Aid, also on behalf of the enhanced amici.
Morning, Your Honor. Caitlin Byers, also from Community Legal Aid, on behalf of the enhanced amici.
All right. Thank you all. You can also see a black box for Meg DeMarco, who is our, okay. Ms. DeMarco's black box is there too. She's another court staffer who's handling the technical aspects of this hearing. Again, my apologies to counsel and to their clients and to the people out there in the YouTube world who have been waiting for 26 minutes for this hearing to start. We've had unprecedented technical difficulties, and that's saying something because we've had a lot of technical difficulties in shifting to a virtual court environment, but this maybe because of the YouTube add-on has been particularly difficult. And so I do apologize for keeping you all waiting. But we're here and we apparently have things working. So if any of the lawyers have trouble hearing me at any point, please raise your hand and I'll stop and we can see if we can fix it. All right, we're here today because the plaintiffs have sought a preliminary injunction that would prevent the state defendants from enforcing the eviction or portions of the eviction moratorium statute enacted by the legislature and signed into law back in late April. We have Mr. Vetstein for the plaintiffs, Ms. Graney for the state defendants, and I've allowed Mr. Mikalakis to speak for the what we're calling the enhanced amici, for organizations that move to intervene as defendants in this case. I denied that motion, but thought it appropriate to let Mr. Mikalakis not only submit a brief and factual materials, but also to argue at this point. And I say Mr. Mikalakis, but of course, with the help of at least the four other attorneys here that we just met. Let me begin by asking a few preliminary questions. There's been a change or two in this case, since we last met and set the schedule that brought us here today, in particular, the plaintiffs have withdrawn their federal claims from this lawsuit because of a parallel federal case, I gather. So let me make sure that I understand what's left. As I understand it, we have a separation of powers argument under Article 30 of the state constitution, an access to the courts argument under Articles 11 and 29 of the state constitution, and a takings argument under the state constitutional provision concerning takings without just compensation. That's my understanding of the three issues that are left. Mr. Vetstein, as lawyer for the plaintiffs, do you agree with that? You're muted, sir. I'm sorry.
Yes, we agree that those three claims are what is alive and pending right now.
All right. On the access to the courts issue, you've cited in your original petition, which is in essence your brief in support of the preliminary injunction application, you've cited Articles 11 and 29. I don't think you mentioned Article 29 in your reply brief at all, and I didn't see much of it mentioned in your original filing. Is this really an Article 11 claim, or is there something that Article 29 adds that you're still relying on?
No, it's an Article 11 claim. 29 obviously speaks to the right to petition generally, but all the case law has been developed under Article 11, so that is what we're proceeding under predominantly.
Okay. And my last preliminary question is that, as I mentioned a few minutes ago, there is a federal court analog to this case proceeding apace, in which I gather those federal claims that you withdrew from this case are being litigated. I've seen Judge Wolf's preliminary order setting some scheduling, but I don't know what's happened in the federal case since. So I'm wondering if you'd just give me a very brief report of where that case is.
Sure, Your Honor. So we filed the federal case approximately 3 weeks ago. And again, we withdrew the federal claims from this suit to essentially put them into the federal suit. Originally, we had a preliminary injunction hearing scheduled. However, Judge Wolf took that off the list, if you will. We are scheduled to have a hearing next week, I believe on Tuesday, on the interveners, which would be the same group of interveners in this case. They're moving to intervene in the federal case. And that hearing is on the 4th of August. And Judge Wolf has also mentioned he wanted to have a scheduling conference at that hearing. So I assume, though it's not certain, that he would set the motion for preliminary injunction down for hearing. Certainly we're going to be looking for that. We've also set up a briefing schedule on our motion for preliminary injunction there. And also the Attorney General has filed a motion to dismiss in federal court, and we've set up a briefing schedule on that. And there's no hearing scheduled on that. So as we sit here today, there's no injunction in place in federal court. There's no pending order. There's nothing that would affect this case, in my opinion.
All right. Let me ask Ms. Graney, is there anything you'd like to add to what I've just heard from Mr. Vetstein about the federal case?
Thank you, Judge. Yes, I think Mr. Vetstein's been accurate. The only thing that I would add is, in addition to bringing the motion to dismiss last week, we also fully briefed the plaintiff's motion for preliminary injunction, and our brief was due in on Monday, the 27th. So that case is briefed except for an expected reply. That motion is briefed except for an expected reply.
Okay, thank you. All right, are there any other preliminary matters that the lawyers would like to discuss before we launch into the substance of the arguments here?
Your Honor, I just like to, because we're obviously dealing with an amicus participation and argument. So my preference is, I assume I would go first, and then the Attorney General would go after me. I'd like the chance to respond to any of the Attorney General's arguments after my sister goes, and then I assume then it would go to Attorney Michalakis, and then after he goes, I would like a chance to respond to what he says instead of waiting till the very end to respond to both.
Okay, well, I have in mind a slightly different format here. I think since we have three different constitutional issues, it makes sense to deal with them by having the three lawyers make their arguments on each of them separately, and then we'll move on to the next one. The order you propose, though, with you going first as the moving party and Ms. Graney responding as the party at whom the movement is aimed, and then Mr. Michalakis as amicus commenting seems to make sense. And I would, of course, go back to you for any rebuttal of what either of the other two lawyers have to say. So that's how I would prefer to handle, break this argument into this hearing into our three separate arguments, if you will, on each of the three constitutional issues. All right, so let's start with the separation of powers issue. Mr. Vetstein, you say, and I should say I've read all the briefs with concentration, and thought quite a bit about the arguments that the three briefs, well, plus a reply brief, make on these points. So you don't need to start from the adoption of the state constitution. I am familiar generally with the legal doctrines and the legal arguments all three parties, or both parties and the amici are making. So with that background about what I know, I'll ask you, Mr. Vetstein, to tell me why there's a separation. Well, let me step back a step from there. Let me say that we're going to begin, because this is an injunction hearing, not a summary judgment hearing, by talking about likelihood of success on the merits. I'm going to ask each counsel to talk about their constitutional arguments in the context of deciding at the end of the day whether the plaintiffs have established a likelihood that they're going to succeed on the merits in their constitutional challenges. That's sort of the overlay here, but it doesn't change the arguments. So to establish a likelihood of success in the merits, it's the burden of the plaintiff, or plaintiffs in this case, to tell me now why their constitutional arguments are going to carry the day at the end of this case. So with that background, Mr. Vetstein, please tell me why there's a separation of powers argument that you think the plaintiffs are going to win at the end of the day in this case.
Thank you, Your Honor. So as Your Honor knows, our Article 30 of the state constitution provides essentially a separation of powers between the three branches, and what it forbids is specifically in this case, the legislature essentially telling the courts how to operate and how to impact their core functions. And this cases speak to core functions of the court. It speaks to altering judgments of the court. It speaks to the legislature usurping the role of the judiciary. And this act does that in several respects. The first, major impediment is that the act is a wholesale, obviously, moratorium on the filing of virtually every type of summary process case in the Commonwealth. And that's something that's never been done before in the entire history of the Commonwealth on a statewide level. But what really causes concerns with the separation of powers is it's not just a moratorium on cases, but it goes into the granular level of what a housing court judge can do on a case. And if you look at the specific provisions of the act, it goes so far as to, I would say, micromanage how a housing court judge handles his or her own case docket. It says you cannot even schedule a court event. It doesn't define what a court event is. Ostensibly, that would be the court can't schedule a pretrial conference, can't schedule a mediation, can't schedule a motion hearing, can't do anything. No trials can be scheduled, both bench and jury trials. Obviously, no new case entries, no stays or no executions can be issued, which we'll get into later in terms of the irreparable harm. There's a major difference between the actual filing of an eviction case in housing court. Then the last step is the move out order. there's a long process that takes place between the filing and then the move out order. But essentially, the act puts a freeze on every single component that a trial justice could do to manage his or her own case. Whereas in some states who have moratoriums, they didn't use this, what they call this nuclear option. They let cases be filed, they let mediations go forward, they let certain aspects of the proceedings go forward. So it would give the judges the autonomy to do what judges do best, which is to judge a case on an individual basis. So in the COVID context, if a tenant comes in and says, Your Honor, I've lost my job because of COVID, and if I get moved out, I'm gonna be rendered homeless, under present statute, a judge can consider all of those COVID-related issues. Conversely, if a tenant, and there's been plenty of, even in our case, in Linda Smith case, if a tenant comes in and says, well, I don't want to pay rent because the governor says I don't have to pay rent because there's a moratorium and you can't do anything about it in the evict. Well, that's a perversion of the statute. And a judge could say, well, let's take a look at did you get the stimulus check? Did you get the unemployment? Do you have the means to pay? If you do have the means to pay, then I'm going to let this landlord go forward. So it takes away all that discretion. It's kind of like the sentencing cases that I cited where, and obviously we're talking civil, but there's a corollary, is that it's within the trial judge's, any judge's exclusive authority as a judge to be an independent fact finder in a particular case. And that's completely taken away. The other thing it does is the case law talks about altering or modifying judgments. Now, Mr. Matorin's case is a classic example of this because he has a pending housing court case. And when he initially filed, he was owed $2,400, which doesn't seem like a lot. But that case has been frozen in place. And now, as the other update, Judge, I'm sure you've heard or read that the governor extended the duration of the act to late October. So at the earliest, and I'll get into this, the earliest that Mr. Matorin would be back in court would be late October, and most likely many, many months after that, because of, and we'll talk about all the COVID-related procedures that the housing court has put in place, which are going to significantly delay current cases and new cases. But by the time that he gets his day in court, which would be probably sometime in 2021, he's going to be owed 6 to 10 times that amount. And that's a direct impact on a judgment of the court. And if you multiply that.
Mr. Vetstein, can I stop you there, sir? You just said it's a direct impact on a judgment of the court. The Attorney General argues that the separation of powers limitations on legislative power do not arise until there is a judgment of the court. And what the case law says, interpreting the constitutional provision, is that the legislature cannot interfere. Once the court has issued a judgment, the legislature can't interfere with that judgment. What the situation you've just described with Mr. Matorin, there is no judgment yet, because I think that's the case that was stopped in its tracks partway on the route to judgment.
Yes.
But I think the Attorney General is arguing that there is no precedent for saying that the legislature has violated Article 30 when it has done something about a court's jurisdiction that precedes the entry of an actual judgment. What do you say to that?
Well, I say that there are many tenants, many landlords, and I believe even a few that submitted amicus submissions for us, who do have a pending, an actual housing court judgment for money damages and also an execution. So as to Mr. Matorin himself, no, that's not the case, but we all know that this case is much more, it's not just about the plaintiffs, it's about the entire rental property community, as well as the tenant community as well. And Mr. Michaelakis has brought those folks in. So there's definitely many hundreds of judgments that are now on hold for, say, a couple $1,000s, but now if you put in a 10-month delay, you're going to tack in, and I would say, probably 90% of those cases, the tenants are not paying, anecdotally. And so those judgments are absolutely going to be affected. But that's just one that's one string of the case law on separation of powers. The other is the core functions aspect. And that's actually really, I feel, is the better argument for us, is that it impacts the core functions of what a trial judge and the housing court judge, that's their everyday job, is to assess the pros and cons of everyone's individual situation.
Okay.
So I don't want to belabor the point, because I think I have two even stronger arguments on right to access and takings. So I don't know if you wanted me to jump to those, or you wanted the Attorney General to.
Let's stop there. I'll have Ms. Graney respond just on the separation of powers argument. It is true, as Mr. Vetstein has just said, that this statute interferes with every function of a housing court judge, some of which I suppose are likely to be core functions if you consider, as Mr. Vetstein says, the right to go in front of a judge and make your case that you should be sent to mediation. The things that housing courts do, every function, including the core ones, is interfered with, he says. What about that?
So, Your Honor, this legislation does not interfere with the inherent powers of the court at all. So it's very clear that the legislature has the ability to set the jurisdiction of the courts that are lower courts than the SJC. So for all of the trial courts, the legislature has the ability to determine jurisdiction. Legislature certainly has ability to make all sorts of changes, not only to statutory causes of action, but also to common law causes of action, imposing statutes of limitations, imposing statutes of repose. The inherent powers of the judiciary are those powers that are granted to the judiciary, not by statute, but by the Declaration of Rights. And that is really a pretty narrow category. The inherent powers involve the right to decide the cases. So if a case has been decided, the legislature cannot then attempt to change the outcome. Or in the instance of one of the cases cited by Mr. Vetstein, can't interfere to restore a dismissed case to the docket. So the legislature certainly can't do that. Also, it is inherent in the Declaration of Rights that judges will decide cases. So the legislature cannot substitute its judgment for that of the court. So those inherent powers are very limited. They're the powers that come from the Constitution, not from the statutes. Chapter 239 is entirely statutory. So Chapter 239 exists because the legislature enacted it. And there's no doubt that the legislature can, without violating the separation of powers, make changes to Chapter 239, create, possibly delay by putting in different kinds of procedural requirements. And that's essentially what's happening here. There's been a freeze on actions. There certainly has been no interference with the judgments. The judgments that have been issued and are awaiting execution or have also had an execution issued, they're simply frozen in time with a tolling provision in the statute that makes clear that no landlord's rights are going to be lost while the moratorium is in place. So those decisions are not being interfered with at all, nor is any future decision being interfered with. The judiciary will be deciding the cases, not the legislature. And the idea that the ability to have a judgment satisfied it relates to interference with that judgment, I think is incorrect. That is not the case. Mr. Vetstein is talking about the possibility that money judgments won't ever be satisfied. That is not a function of the legislation or related at all to the content of the judgment. The judgment remains. How one goes about satisfying it and whether ultimately they're able to is really unrelated to the separation of powers and certainly unrelated to the statute.
What about the point where you get to the point where you've got a judgment in place, a judgment not for money, but for possession, and you got that judgment from the housing court the day before this moratorium was signed into law, and now you can't, the statute says, go take an execution and get your possession back. Isn't that, in essence, the legislature interfering with the with a judgment issued by a court?
No, Your Honor. I think that's akin to a stay, and there are many situations. Certainly, the court can issue stays. There are many, and there's legislation that provides for certain types of stays. For example, in Chapter 239, Sections 9 and 10. There are particular circumstances enumerated where judges can grant a stay of execution. And staying the issuance of the execution does not in any way interfere with the judgment. The only problem could arise if the judgment, and summary process judgments for possession do have a short shelf life, so to speak. The only problem could arise would be if the judgment itself was going to become unenforceable because of the passage of time. But the legislation takes care of that because of the tolling provisions. So there's no way that any landlord who already has a judgment for possession is going to be deprived of that judgment or have that judgment changed once the moratorium is lifted. They will then be able to go ahead and proceed and request an execution. Although, as the plaintiffs argue that, eventually having to do a forced eviction through an execution is relatively rare. Certainly, issuance of execution is not rare. It's about 2,000 a year or something like that in Boston. But that staying of the execution does not interfere with the judgment. The judgment remains.
All right. Good enough.
Your Honor, may I make one quick point, Your Honor?
Yes.
Okay. Ms. Greeny actually makes my point. What she's basically saying is that, especially with respect to stays of execution, granting a stay of an execution is a purely judicial function. What she's saying is that a state representative can get up there, the housing court bench, and say, we're going to grant a stay or we're going to deny a stay. And in fact, the act itself says and mandates that a court shall not deny upon the request of a defendant a stay of execution or upon a request by a party continuance of a summary process case. That's literally what a judge does. And Article 3 says a legislature has to be exactly that. They're lawmakers. They're not judges. And judges, vice versa, are not lawmakers. And we hear so much about activist judges and this and that, legislating from the bench. But this is literally state reps trying to be housing court judges. And it's gone too far.
I gotcha.
So could I respond to that, Your Honor?
Very briefly, yeah.
So it's simply not true that the legislature can't affect stays or put into place stays. There are, right in Chapter 239, there are two provisions for stays. In particular, Section 9, which speaks to stays of execution for situations where there's an elderly person or a disabled person. So absolutely, the legislature can pass a statute that requires or allows stays in different situations without running afoul of the separation of powers.
Grants
a judicial officer. Yeah, grants a judicial officer. Yeah. Okay. Moving on now.
I'd like to move on to Mr. Mikolaitis on the subject of the separation of powers argument. What do you have to say about this, sir?
Sure, Your Honor. So I will say, sort of as a threshold issue, you'll notice from having read our brief, we didn't really comment on the separation of powers directly. as opposed to some of the other legal issues, just because I think it's less factual, more legal. But I do have a couple of general points to make. I mean, first, this will come up, I'm sure, multiple times in this argument, but just the standard of review generally, given that what's happening here is a modification of a legislatively created cause of action, it's rational basis review, right? Whether or not, in light of the tremendous public policy interests here, whether or not there's an absence of any rational connection between the goal the legislature is seeking to accomplish and what the statute actually does. So I'll say that generally. I think we'll get into that more when it comes to some of the other legal issues, but I think it's important in your consideration of this as well. The other sort of general point I'll make is I'll echo what my sister said regarding the legal character of summary process. It is a creature of statute. We spent a lot of real estate in our brief talking about that. And I would emphasize that it's not just, it's a legislative creation, both in terms of the cause of action and in terms of how ultimately judgments are to be enforced. Like any judgment, the manner in which a summary process judgment is executed upon is prescribed by the legislature, specifically at Chapter 235, Section 23. And well, not just there, but the timing, which is obviously a relevant issue here, given that we're talking about a pause on all evictions, is prescribed at 235.23. It says that judgments for possession have to be, you have to get an execution within 90 days of the judgment and then use it, as in levy upon it, within 90 days of getting it. The legislature took great pains to make sure that that deadline, along with any and all summary process deadlines, was told by the enactment of the legislation. So it truly is a pause, a preservation of the status quo with respect to cases that were in motion at the time of enactment. In fact, if you read the statutory text, Section 3C, it says specifically, it specifically denotes levy upon an execution of possession as one of the events that is expressly told. So I think that's, I'm not going to rehash the Attorney General's arguments. I agree with basically all of them, but I do think that additional point is really important.
And I appreciate it. And you've actually started to move us into the second constitutional argument, it seems to me, which is whether the legislature has the right, without violating Article 11, to temporarily deny access to the courts in a particular species of lawsuit. So let me go back to Mr. Vetstein and ask him to tell me why you think you're going to succeed on the merits in this case on your access to the courts argument.
Thank you, Your Honor. So what I was going to mention in the former argument, but it's also relevant here, is that the remedy of eviction, or for a landlord to retake possession from a tenant, has been part of the Massachusetts common law since the colonial days, and it goes back to the English days. We cited case law going back to the 1800s discussing all those that remedy, which back then there wasn't a summary process statute. So all that Chapter 239 did is it set up a procedure for the exercise of the long-standing common law right of eviction. That common law right has always been part of Massachusetts jurisprudence, going back 300 years. So it's not, Chapter 239, I think my brothers and sisters make too much of it. It's a procedural statute. It sets up rules and frameworks, but we're talking about the very essence of the right to own and possess real property, which, if you look at the case law, McCarthy versus Tobin, Davis v. Commonwealth, says that Massachusetts places a great weight on ownership of property, probably going back to the colonial and English days. So when we're talking about
Can I interrupt and ask you, you've just said that there's a common law right here. The legislature enacted a summary process statute to, I guess you would say, outline a procedure for exercising your common law rights as a landowner or landlord. But in the course of doing that, the legislature changed a lot of that common law right. Before there was a summary process statute, you could use self-help, right? You could change the locks. For all I know, back before I was born, you could go and toss people's furniture into the street without going to a court. And the legislature said, no, there is a common law right. We're going to put some bounds on it. Here's a summary process statute. And that statute has in it certain built-in delays, right? Because the statute says you can't go to court. You can't file your lawsuit until you've terminated the lease, until you've sent a notice to quit, and certain periods have passed. So the legislature has already taken that common law right and put a structure around it, a procedure around it, as you say, that in some cases takes away aspects of the original common law right, and in some ways actually puts time limits on how long you got to wait before you can go to court. So doesn't that prove the Attorney General's point that the legislature has the ability to modify or to delay relief under the old common law right of eviction?
They have the right to, if we're talking separation of powers, they certainly have the right to impose reasonable rules for judges to impose. So the state statute 239, 9 and 10 authorizes judges to issue stays. Judges, not legislators. What we're talking about here is a total evisceration of that common law right. And to a great extent, yes, 239 essentially for the current day provides the exclusive remedy for exercise of that common law right. But what the moratorium does, and as something has never happened before, is it eviscerates that right. It takes away that right completely across the board and applies to virtually every sort of summary process, not just non-payment, but no fault cases, certain cases that wouldn't fall under the exception for criminal activity, holdover tenancies, a whole host of issues. So it does a lot more than just not reasonable regulation. It's, again, like I said, the nuclear option. It blows up 239 completely. So that's when I talk about, pre-existing common law rights, I'm talking about why it's a fundamental right, why it's a fundamental, we dovetail to a fundamental constitutional right to have your day in court. And actually, if you look at Article 1 of Declaration of Rights, interestingly, and we didn't cite this in the brief, it just came out recently in our research, but and I'm sure a lot of people read this, all men are born free and equal, having certain natural and essential and unalienable rights, among which may be reckoned, quote, that of acquiring, possessing, and protecting property. And that's our state constitution, the very first Article 1. So obviously the framers, the founding fathers, thought that our property rights were in the nature of fundamental constitutional rights. So when you're talking about access to courts, there is a constitutional right to file a lawsuit with respect to your property rights, and especially whereas here you have tenants who in many cases are not paying rent, either their own fault or through COVID, but you are literally forcing landlords across the state to publicly house or provide public housing to landlords because of this moratorium.
Let's not go into that's Mr. Vestine, that's a takings argument. We'll get there. Let me just ask you if you agree that the legislature could appropriately have done what it did here.
You just cut out a little bit there, but was your question, is it appropriate for the legislature?
I'm sorry, I'm getting, there's a delay in when you're speaking, and so can I hold on just a second? I'm going to ask my clerk to turn up the volume in the courtroom behind me, because I'm sometimes hearing you through that, and sometimes my computer sometimes not working. So just give me a second.
Okay.
Can you turn up the volume? So we're doing what we can to make sure that I can hear you. Usually I'm hearing you through my computer, but sometimes you cut out and I'm listening to the courtroom, which is 5 seconds behind. So I'm hearing what you're saying, but it's technologically difficult again. Let me ask you, do you agree? You agree, I think, that the legislature can say in enacting the summary process statute, you cannot go to court until you've sent a notice to quit or terminated the lease, or both in many cases anyway. The only difference that you've pointed out here, it seems to me, is that this doesn't set a deadline on the period in which you can't go to court. This is indefinite, as opposed to you can go to court only 14 days after you send a notice to quit or whatever. Is there any other difference between saying what the legislature said now and saying what it said years ago in imposing time limits before you could go to court for an eviction?
Well, I mean, certainly they can impose a notice to quit requirement, and that's also long been part of the common law. And that's something that's within a landlord's control to do. So the landlord is the one who issues that notice. And it also provides functionality in the sense that it encourages resolution of disputes. So there's utility for that as well. But what makes this different is, and especially for folks that have pending eviction cases, that it literally just stops the court from operating altogether. And that's totally, not within any plaintiff's control in a summary process case. And actually some of the other statute moratoriums, and what I think would be okay if the legislature did it in this case, would be to tweak the stay statute, which to say, we'll let landlords file evictions and we'll let certain cases proceed and all that. But, and New York did this, I believe, and perhaps another state, and I can give you that site. If you have a COVID-related hardship on a motion for stay of execution, the court can consider that. And that's, I think, proper exercise of legislative function on summary process. But again, just there's a big difference between that and, again, going nuclear and shutting the whole process down. That's saying to a housing court judge, you can't even schedule a court event at all. I mean, so everyone, and we've been on bench bar conferences and they've said, the judges say, we can't, we can't schedule anything, and we're not going to schedule anything, and don't even try to file it. We're going to reject it. So we tried to file even agreements for judgment. We had agreements that were actually negotiated outside court, and they tried to file it in court, in the housing court, and e-file, and it got rejected. They wouldn't even accept it. So it shuts the whole thing down. And that's why it goes over the line.
All right, let me ask you this about the law. The cases you cited in your brief on this point were really cases in which the courts have found that judges violated Article 11 by preventing people from coming to court before they jumped through some other hoop, went to mediation in a divorce case, for instance. I didn't see any cases that you cited in which a court in Massachusetts has ever said that the legislature has violated Article 11 by preventing courts from doing something. Is there any such case law?
Your Honor, we couldn't find it, and probably because there's never been such a moratorium on a statewide basis in the 400 years of the Commonwealth's history. I mean, there's a lot, we all talk unprecedented with COVID, but again, this is unprecedented. So this is novel ground, and obviously for Your Honor to, probably make a case of first impression here. But obviously, we have the principles in play, and we can lean on those. So yeah, I mean, it was definitely, first got the.
I'm not saying that because it's never been done, it can't be done now. You're right. This is a very unusual circumstance, no doubt about it. Finally, let me ask you one last question. Ms. Graney suggested in talking about the separation of powers argument that it is really that the jurisdiction of any court in this state below the Supreme Judicial Court is a matter of legislative power to set. I don't, first of all, do you agree with that? And secondly, if you do, isn't this simply a matter of the legislature setting, not even setting jurisdiction, but simply delaying for some period of time, regrettably unknowable how long, the jurisdiction of one of courts to hear a particular kind of case?
Well, yes, certainly I would agree with that. Legislature has the prerogative to legislate jurisdiction. But I mean, if you look at the act itself, there's no express intent to alter jurisdiction here. There's no provision dealing specifically with the courts. I mean, just the general, I mean, unless the Commonwealth is arguing that by way of this moratorium, they've stripped all trial courts of jurisdiction to hear summary process cases, which that would create a major takings problem, obviously. If they're saying that landlords have no right in the Commonwealth to evict tenants under any circumstances, I don't think that's what they're saying. Because if they're saying that, then that is a clear Fifth Amendment violation, because there's no funding that was put in place in this law, and there's no statutory right to compensation. So if they want to go down that road, then I'm happy to argue that. But I think this is simply not so much of a jurisdictional issue, but it's a micromanaging of the actual housing court process, because they go to that granular level of pointing out different scenarios, motions to stay, motions for continuances, defaults, court events. I mean, it's just, I've never seen something as micromanaging as this in terms of legislation dealing with a court. Usually, and my sister has cited, the workers' comp cases or the statute of repose, workers' comp, obviously exclusive remedy, but it doesn't go into, that amount of granular level in terms of what judges can and can't do. Because you're getting very close.
Are you saying it would be okay for the legislature to do here what it did with workers' compensation?
No, I'm not. No, workers' comp is totally different.
Why is it totally different? The legislature said you can no longer sue your employer for negligence.
Because we're talking
about a
about
whole class of cases and said,
easy answer. It's a fundamental property right that's in the state constitution and the U.S. Constitution. You have property ownership is a fundamental constitutional right. If you getting hurt on the job and filing a claim, it's not a constitutional right to collect damages. That's the difference.
So you're saying that since negligence generally is a common law concept, not in the Constitution, the legislature could say nobody can sue anybody for negligence. We're going to remove all of that from the courts of Massachusetts, and they could do that because it's not a constitutional right like the property interest is.
If they try to remove all types of negligence, that's a pretty that's a law review article right there. So I'd have to research that and get back to you. Again, the distinction I'm trying to draw is, I think we're getting, I'm all for hypotheticals, but again, that we go back to the essence of real property and how Massachusetts treats property ownership with McCarthy v. Tobin and Davis v. Comerford and Article 1 of the state constitution and the Fifth Amendment. It's a very important part of American jurisprudence.
And it's unfair of me to make up hypotheticals that occur to me and ask you to write your law review article on the spot. So I understand your reluctance to answer directly because it's, it may not be something you've thought about. And that's perfectly okay. Let me go on to Ms. Graney and ask her why you think that the plaintiffs will not succeed on the merits concerning their access to the courts issue.
Thank you, Your Honor. Well, Mr. Vetstein hit the nail on the head when he said that the right to possess property is a common law right. He is correct that it's a common law right that goes back hundreds of years, but it is a common law right. And because it is a common law right, the legislature can make changes, and and so can potentially courts. It is not a fundamental constitutional right. That is not argued in the plaintiff's brief, and it couldn't be argued because they would not find anything to support that. It's a common law right because the theory of real property is that property was originally derived from the sovereign. So implied in property ownership is the ability of the sovereign, the state, to regulate property ownership, to regulate property use. Now, a classic example of how the right to common law possession has changed over the years is, and landlord-tenants' rights, is the Hemingway case, which the plaintiffs do cite in their brief. And that was a 1970s case that abolished the covenant, the independent, the theory that the covenants in a lease were independent. So it used to be at common law that the only thing that was owed to the tenant by the landlord was literally possession of the land. There was no obligation to provide a habitable premises or a building at all. So the building could burn down and the tenant would still owe the rent. In Hemingway and also in 239 section 8A, both the legislature and the Supreme Judicial Court really have changed that in the context of residential tenancies. So now there is a mutuality of covenants, and the tenants, the landlord does have an obligation to provide a habitable premises. And in 239 section 8A, tenants can have a defense to eviction, can have a defense to the landlord's possession in the event that the premises is not habitable, that the premises is actually, worth less than what they've been paying or what they've had to pay to make it habitable themselves. There are all sorts of defenses now. In fact, the Michael case, Nurse v. Michael, that's the case that says that it can be a defense to eviction if there's a violation of the security deposit statute. So there are all sorts of changes to the common law of real estate and common law of possession that the legislature has enacted. And the reason that the legislature has that power is because these are, in fact, common law rights. And the same is true with any sort of action that is taken away by a change to a statute of limitations or a statute of repose, et cetera. There is an ability to change the common law. And that's an important distinction between common law rights and fundamental rights. Also, it's clear that eviction is a remedy. It is one remedy among others for the violation of a lease. And the legislation here, the Emergency Act, in no way prevents landlords from going to court. Landlords still have every opportunity to go to court on a collection action. And the Enhanced Amici, in one of their affidavits, has actually supplied citations to cases that have been filed in the non-summary process sessions of the housing court to collect rent. There is absolutely nothing that prevents the landlords from vindicating their rights under the lease by seeking payment of rent. The only thing that has happened is that the legislature has delayed the remedy of possession, and that it certainly has the right to do without violating the right of access to the courts. The two major aspects of the right of access to the courts are that people with a dispute are entitled to have a resolution by a judge, and they do not have to purchase justice. So it would be a violation, and this is why most of the cases talk about things that judges have done, Bowers and Ventris. I may mix them up, but in one of those cases, there was a parent coordinator who was, I think that's Bowers, it was a parent coordinator who was appointed in the family court and given power that the parents didn't consent to, and essentially usurped the judicial function of the judge to decide the case. And similarly, in the other of those two cases, I think Ventris, there was a requirement that the parties mediate. That is a violation of the right of access, because the parties with a dispute have a right to have justice done by a judge. So a judge can certainly encourage parties to mediate, can certainly suggest that it's a good idea, but to require a party to mediate as sort of a requirement for, getting into the courtroom, getting past the courtroom door, especially if I have to pay for it, would be more concerning. In the case of this legislation, there's no way in which the judicial function of deciding the cases is being denied to the landlords. Landlords have a present right to go ahead and try to recover any rent that's due, and they are able, there's a tolling provision that completely stays all of their rights to regain possession. And I would, by the way, make the point that this is not open-ended. This is not an indeterminate time period, which the plaintiffs do suggest in their brief. It is tied to the state of emergency. So the statute does not allow the moratorium to exist for more than 45 days beyond the end of the state of emergency. So this isn't some sort of open-ended time period. But there certainly is plenty of case law that suggests that legislatures can alter common law property rights, especially during an emergency. Block v. Hirsch is an example, many cases involving rent stabilization. There are lots of cases that are examples of that. So there really is no right of access to the courts problem here at all. The landlords have access to the courts.
Can I ask you about the case in federal court before Judge Stearns about the Attorney General's regulations issued because of the COVID emergency under Chapter 93A, which prevented debt collectors from filing lawsuits during the pandemic. Mr. Vetstein says correctly, I think, that you don't really address that decision, in which Judge Stearns enjoined the enforcement of that regulation, depriving a certain category of creditors from access to the courts during the pandemic. Does that apply here? Does the same reason apply here?
We don't address that case because of the change that the plaintiffs made to what they're actually arguing in this court when they withdrew their federal claims. So Judge Stearns very clearly limited himself to the federal claims because of the 11th Amendment, and didn't, even though there were state law theories brought in that case, he did not reach them. And he only focused on the federal theories. So it was a right to petition under the First Amendment, not a right of access to the courts under Section 11 of the Declaration of Rights. I will say what we would have said if we kept our federal arguments in the brief that we gave you, which is that that case did not involve an act of the legislature. And certainly there's been no case cited where an act of the legislature has been found to violate the right of access to the courts. Generally speaking, the cases that are discussed in ACA did not involve legislative acts being overturned at all. So I just would suggest that the reasoning in that case should not be adopted here for a couple of reasons, one of which is that Judge Stearns very carefully avoided any state law questions, and the state law questions are the only questions that are now before this court.
All right, thank you. All right, let me go to Mr. Mikolakis and say, is there something you'd like to add on this this issue of the constitutional violation here, allegedly?
I would love to start with ACA v. Healy because we actually addressed it in our brief substantively as well. I think there's a huge difference between any act, legislative, regulatory, whatever the case may be, that takes away all remedies to pursue a particular cause of action, or put differently, to pursue petitioning activity through the courts, and legislation like this one that takes away a remedy. And that's the latter situation is what we're in here. Summary process is a remedy for enforcing lease violations, including non-payment of rent, but not just non-payment of rent. There are other remedies. As my sister pointed out, we cited in our brief some post-moratorium cases that have been filed, breach of contract suit against a guarantor for non-payment of rent, as well as a breach of contract suit for injunctive relief against unlawful subletters, and then for damages as to the tenants of record. And those actions are not barred or in any way modified, in any way affected by the enactment of the moratorium law. The First Amendment, it doesn't protect.
I appreciated your pointing those cases out in the brief. I had not thought through until I saw your brief that a landlord can sue a tenant for a breach of contract for failure to pay rent and pursue that. The answer to that, however, I think Mr. Vetstein would say is, why would you spend the money to chase somebody who's maybe, hopefully, doesn't even have the money to pay the rent, and that's why the person's not paying the rent? Is that a real remedy anyway?
Well, I think, to be honest, I think that's a discussion we should be having in a few minutes when we get to takings, as opposed to this discussion, which is the First Amendment, right? The issue here is whether or not the landlord has the ability to petition the court for that grievance, right? To put on a piece of paper and turn it into a judge about non-payment of rent, and they can still do that. When we talk about takings, I will certainly go into a little bit more why I think the existence of that remedy is relevant there too. But I think for the current purposes, the existence of a formal remedy is enough, because the whole point is to go into court for redress of grievances. And I think that piece, that this is a remedy, it might not be the preferred remedy of landlords, is also important when you circle back to the standard of review, which again, I submit is rational basis. You're not taking away all remedy to petition the government for issues related to landlord-tenant concerns. And when that's going on, it's rational basis. And here, the legislature's actions are plainly rationally connected to plausible, protectable government interests in the face of a horrifying, unprecedented global pandemic. I mean, again, this is something I was planning on bringing up in the taking section later, but I think it's also relevant now. There's a lot of research. Some of it's cited in our brief, some of it's cited in other amicus briefs. The ACLU Matt Desmond brief in particular talks about how the mere act of filing an eviction causes harms to tenants, right? And in some cases, predicate acts such as service of a notice to quit prior to initiating an action. It can incentivize tenants to move out and not pursue or vindicate their rights in court. The filing of an eviction obviously can also, in the Commonwealth and in other states, to the extent that those records are searchable and publicly available, which here they are, it blacklists tenants from being able to find new housing, which again, in the context.
Well, I understand all that. I think
is. So I apologize if you.
Yeah, I appreciate those arguments. I read the ACLU brief, and I understand that. I think they're a little off the legal point that I'm trying to get at right now. So let me go back to Mr. Vetstein and say, what do you say to what Mr. Mikolakis has just said, that this is removing one remedy and leaving lots of others? For instance, if I had a tenant who said to me, I'm not paying the rent, not because I don't have it, but because the governor says I don't have to, assuming that actually happened, that would seem to me as a landlord to invite me to go sue that person for breach of contract and collect the money, because that remedy is open to your particular plaintiff and any other landlord. What about that?
Yep. So 2 points. I'll address the the non-payment situation. So the fundamental obligation in any lease is a tenant pays rent and they're allowed to stay in the unit. Tenant doesn't pay rent and they're not allowed to stay. It is the core obligation, rent for possession. So when you take away the right to evict, you've eviscerated the fundamental remedy. There's no, if someone owes you 20 grand in unpaid rent, what's going to be more effective? Filing an eviction or filing a small claims case in Lowell District Court, which is going to take them 6 months to resolve, and all they're going to get is a money judgment in the mail. That's it. That'll effectively allow them to stay in possession, and that's the whole issue. The whole issue, it's not about money. It's not about money. It's about property rights. It's about the right to possession. That's the key.
But the legislature has done that in the past. It has said in the condo conversion cases, Grace versus Brookline, the Cambridge case, that if you're converting your rental unit into a condominium, you cannot go to housing court or anywhere to do an eviction for 6 months. It said, the legislature said similar things in the mobile home park cases coming out of Essex County back in the day, from Chelmsford and those cases in which it said there are only a few narrow reasons that you can file an eviction case against a mobile home tenant, if you will. And by the way, you got to wait a period of time, 6 months, whatever, before you can do that. So the legislature has done this before and survived constitutional challenge in the SJC in those cases, right? What's the difference here?
Well, so I reread the Grace case and the other case last night, and I knew this was going to come up. So those were in the context of rent control, and it was conditioned on the payment of rent. And actually, the landlords could actually go back to the rent control board and ask for adjustments for the rent and market value. And same thing with the Yee versus Escondido case. That was also conditioned on the payment of rent. Also rent control. Obviously, rent control is a totally different animal than a moratorium. So you're in rent control, you're not taking away the fundamental remedy. And the Grace case, again, those were city bylaws, home rule petitions. Again, just the town of Brookline, and the city of Cambridge says, because of the particular situations involving our town, we're going to put in rent control and we're going to have a condo conversion. Essentially, I wouldn't even call it a moratorium, but we're going to have a stay on evictions, provided that the landlord has reasonable safeguards to provide for security. So that's another flaw with this act, is that it doesn't mandate, it doesn't provide that the tenant has to pay money to the landlord to maintain a stay of eviction, or pay money into court, or do a rent escrow, kind of provide that security. And then it does have a last month's rent provision, but that's essentially a loan that has to be paid back by the landlord at the end. In New York's moratorium, they allowed for security deposits to be used as for rent, and security deposit is over and above. Usually the landlords collect here in Mass first, last, and security. So security is technically owed a property of the tenant. So there's none of those safeguards here, which makes it different. So that's why. The other point I want to raise is that we're a lot of talk about non-payment, not a lot of talk about all the no-fault cases or the cause cases. So what's the remedy? I'll ask my brother and sister, what's the remedy in a situation where there's an oral tenancy at will, a no-fault, and where a lease is expired, or I'm sorry, not a lease, but an oral tenancy at will, and another family wants to move in, and there's a holdover tenancy. You're going to file a breach of contract case in district court, which is closed? No, you file a summary process case because that tenant has to move out because you have another family coming in. Or you have a cause case where it doesn't necessarily, and the standard is criminal activity which impacts the health and safety of other residents. So, a lot of, noise issues that may be contained in the unit, marijuana smoking, cleanliness, damage, a whole host of kind of cause related issues that don't fall within the non-essential eviction. Again, what's the remedy there? You're going to file a breach of contract? What contract for a holdover tenant? There's no contract in most cases. The only remedy is summary process. And when you take that away, then that's the problem.
Your Honor, if I could address that for a moment. The Grace case really addresses this issue and many others that we cited, because in Grace, the person who wanted to do a condo conversion couldn't simply get a certificate of eviction for any reason. It was if the owner was going to occupy the unit themselves, or there was just cause. So the ability for the fee simple owner to recover possession was severely limited in Grace. And I think the key here is to keep the right to possession sort of separate from the right to recover rent. They really are two different things. The ability to recover rent is a collection action. Sorry, Your Honor.
Mr. Vestine just said that the regulation in the Grace case was conditioned upon the person, holdover tenant, if you will, getting in the way of the condo conversion, actually paying rent. And if that person didn't pay his or her rent, then the eviction on that person, the moratorium on that person's eviction would disappear. The new owner who wanted to turn it into a condo could race off to court the next day. That's an important distinction here, if he's accurately describing that regulatory regime.
So I would say that in Grace, it wasn't conditioned on the payment of rent. The owner could get a certificate to evict only in certain situations. And one of those situations was non-payment. Yes, in Grace, if the tenant wasn't paying, the owner could apply for an eviction certificate. But the main takeaway here is not that. The main takeaway is that the owner's right to recover possession, even in the event that the tenant is paying rent, for example, when the lease expires, or if he's properly or she's properly terminated the tenancy because they want to convert the unit to a condo. The whole point of that bylaw in Brookline was to preserve rental housing and not allow all of the apartments to quickly become converted into condominiums. So this right to possess the property that the fee simple owner has at common law was very much being interfered with in Grace. And that's the same in all of these other cases where there is rent being paid and there is a mechanism for eviction if rent isn't being paid. But the bottom line is it's very clearly established that the government can, and particularly in times of emergency, interfere with the common law right of possession. And that goes back to Block v. Hirsch, in many cases that we have cited. So I think that the key point is that although rent was being paid, and if it wasn't, an eviction could happen in some of these cases, that is not really why the right of possession was able to be disrupted. The two things don't depend on one another. The right of possession could be disrupted by the state because it's a common law state, and within the police powers of the legislature or whoever the government actor was in the particular case, the ability to affect property rights was clearly constitutional.
Your Honor, may I also be heard briefly in response? Yes. So I think, respectfully, I still don't think my brother has answered the contention I raised, which is that, again, if we're talking about petitioning activity, about the First Amendment, which is my understanding of where we are still, landlords have a way to literally petition the government about non-payment of rent. They also have a way to petition the government about criminal conduct, about conduct in breach of lease, whether or not it meets the bar for essential evictions under the Act. And as I pointed out, landlords are in fact filing those cases. So I think if we're still in First Amendment land, I don't think that point has been answered. And I think the effectiveness of a contract type remedy for recovering rent it's not material to the First Amendment issue. And the second point I would raise is about the no fault scenario that my brother mentioned. The legislature could abolish the ability to evict no fault or severely restrict it tomorrow. They could pass just cause eviction statutes. Other states have those. Some localities in other states have those. That wouldn't be a First Amendment issue. There might be takings issues that are brought up by statutes like those, depending on if there are any exceptions. But that's not a First Amendment issue because the legislature is free to modify and sometimes abolish causes of action. And it seems counterintuitive to me that a pause on a cause of action would get more scrutiny, at least as in terms of talking about the First Amendment, than a total abolition of the same.
Okay, let's move on to the takings argument because it's a little more, it has more steps, I think, than the two we've talked about. And I do want to get ultimately to the irreparable harm argument. So on the taking side, Mr. Vetstein, why don't you tell me why you think that you're going to win ultimately your argument that there's a taking going on here?
Thank you, Your Honor. Yes, the takings argument is fairly complex. We have a question of whether it's a physical taking or a regulatory taking. We believe that it qualifies for both. So as to whether or not it's a physical taking, I point to the Supreme Court Loretto versus teleprompter case, which I call the cable TV case, where there was a New York City ordinance which required all landlords to install cable conduit wires on the exterior of their property. Now, reminder that a cable wire is very, very small and not a, I call it major intrusion into someone's property. The Supreme Court held that that was a taking and the right to just compensate.
Let me ask you this about that example.
Yeah.
There, the government said a private entity, this cable company, could physically occupy real estate. Small piece, as you say, of apartment buildings in Manhattan. You say, as I understand it, that the same thing's going on here because the government is saying private people, that is tenants who aren't paying the rent in some cases, can continue to occupy the much more of the real estate of your clients. However, I hear from Ms. Graney and Mr. Mikalakis that the distinction here is that your clients invited those people in. They signed leases with those people, or they didn't sign leases. They created an at-will tenancy, oral tenancy, whatever. That's a very big difference, is it not, from the government saying that to a private party, you can go on to the property and put your cable equipment there.
Well, the difference is in a traditional landlord-tenant, the landlord selects the tenant, based upon certain qualifications. But then obviously the key aspect of the relationship is the right to occupy the property for the payment of rent, or in some situations post foreclosure, there is no right to possession at all. And if you don't pay, then you have no right to possession. And then what happens, the state comes in and essentially with the act comes up with a statutory regime that in operation, what it does is convert that private property into subsidized state housing. Because what it does in reality on the ground is it creates a situation where tenants do not have to pay rent. And you can find, then Mr. McLaughlin said, they can go file a district court case, go file a summary process case. That's going to do nothing to get them out of the property. They are allowed effectively to live in the property. And obviously human beings have more impact on a property than small cable wires in terms of the entire property. And they're allowed to possess that property against the owner's will. And that's what it makes a difference. I understand your point,
Okay.
and it's a valid point. But that is my response. And also I would note that, the cable TV wires, and there's an argument that, oh, well, it's, the moratorium's temporary. And I do want to address that. Well, can anyone tell me when the moratorium is going to expire? I don't think anyone can tell me that, because he thought it was going to expire in August, and Governor Baker extended it. He has an unlimited right to extend it for 90-day periods. If it's tied to the COVID state of emergency, we know, and it doesn't take a rocket scientist to figure out that Governor Baker is going to keep that state of emergency in place for as long as humanly possible, because federal funding is tied to that. So as we sit here today, the way landlords look at it is it's indefinite. We don't know when it's going to end. Could it end on October 18th? Theoretically.
Oh, I understand all.
Yeah.
I understand
okay.
that.
So anyways.
It is tied to facts anyway, but go on to your regulatory taking argument.
Yeah. So the regulatory taking argument, we have Blair versus Department of Conservation, and obviously the Penn Central case. So I love the line in Blair, which is it's kind of like the U.S. Supreme Court pornography cases. It goes too far. It goes too far. So when does a statute go too far? And we'll talk about economic impact and investment back expectations. But to me, it's a situation where, does it pass the smell test? Does it go too far? And given the historically unprecedented nature of a statewide moratorium on all say 98% of all evictions, the micromanaging of the housing court judges to not schedule certain events, the banning of the notices to quit, and which essentially prevents virtually all formal communication between the landlord and the tenant as to terminations of tenancies. It goes too far in addressing the perceived public policy, which is, and we'll get into that in the irreparable harm, this narrative, which is totally false, that there's going to be a tsunami of evictions, which is then going to lead to homelessness, which is then going to lead to COVID-19 spread. It's like 3 levels of logical leaps that you have to go through. So again, when we talk about investment back expectations, obviously we do recognize that, especially in Massachusetts, it's a highly regulated area, housing. But again,
you said that and it pointed out to me.
Yeah,
you said this is the most heavily regulated housing market in America, which does affect what landlords should expect when they decide to become landlords, shouldn't it?
Well, I mean, I don't think I said Massachusetts is the most heavily regulated. It's probably one of, but if you read, especially the interveners City Life, I mean, they've been speaking all over social media how Massachusetts has now the toughest moratorium in the country. Okay, and where most of the moratoriums are now expiring, or most of them have all these other safeguards, COVID-19 financial hardship requirements, et cetera, the Massachusetts moratorium does not. So I think we can all agree that, yes, the Massachusetts moratorium is the toughest and is the worst in the country in terms of impact on landlords and what they can and can't do. So just because something is highly regulated doesn't mean, I don't think any landlords would have a reasonable expectation that one day they have a tenant who owes them $12,000 and they have a pending summary process case, and the next day someone tells them, you're stuck with these folks at least for the next 6 months, could be 9 months, could even be 12 months. I think that we might be going to the hospital because they might have a heart attack if that's the case. So I don't think, and especially mom and pop landlords, that is all a reasonable investment back expectation to say that there's going to be a statewide moratorium on all evictions for the indefinite future. And it doesn't matter whether it's COVID or not. We've dealt with pandemics before, 1917 pandemic, which was far worse, where 600,000 people died in the United States. And yet, everyone likes to say this is unprecedented. Well, it's actually not unprecedented. We went through this 100 years ago and we made it through. And afterwards, in the 20s, we had a roaring economy, and we're going to get through this too. So the issue is now we're sitting here in August, or almost August, and we have another, August, September, October, another 3 months left. And people are going to be really hurt here. Well, on both sides, we acknowledge that. We feel that it's a strong takings case because of the unprecedented action, and it essentially converts private property into state subsidized housing, and the remedy has been eviscerated. And if a cable conduit wire is a taking, why aren't forced subsidized housing a taking?
Well, you've stated what the Supreme Court gave us all to work with. Does it go too far? That's the Supreme Court's words, and I'm stuck with them, and as our counsel. So let me turn to Ms. Graney and ask, doesn't this go too far to use the Supreme Court's words when it says to landlords, the most basic part of what you expect when you make your investment has been taken away from you, at least temporarily, in cases in which tenants decide not to pay, either because they can't or they won't pay their rent. You can't chase them for possession. That goes awfully far.
So it does not go too far. And by the way, I'm just assuming the court would like me to get right to Penn Central. In terms of physical taking, I just want to say the Yee case clearly distinguishes Loretto, and there's a clear difference between an invited tenant and an occupant that is foisted upon the landowner by the government. That's the key distinction, and it's made very clearly by the Supreme Court in Loretto. So there's definitely no physical taking here. So going to the possibility of a regulatory taking and the Penn Central criteria, this doesn't go too far. And, one of the reasons it doesn't is because the landlords here are consistently misstating what the measure is for the loss of value in a takings case. So they're talking about their ability or inability to recover the income stream from one unit in the property. Again, that's not what a taking is about. That there might be a collection action against the tenant for their inability or refusal to pay that money. But taking is about value of the parcel as a whole, the land and the buildings thereon. And so the measure of whether the economic impact is severe enough to warrant a decision that it's gone too far is the value of the land and the buildings thereon, the whole parcel, before the taking and after the taking. And the landlords claim that a taking, has occurred because of this moratorium, but they have only spoken to their loss of income stream, which isn't the measure. They haven't provided any suggestion or any evidence that the value of their buildings, which both contain multiple units, not just the one that is an issue, they haven't provided any evidence that their buildings have actually been devalued. And so the idea that there's been a significant economic impact is speculative, because there's no information in the case that suggests that the market value of those buildings has declined because of this moratorium. Whether they can continue to receive the income stream in accordance with each particular lease, that does not go to takings. That's not what a taking is about. So there isn't a severe enough impact. And by the way, severe means very severe, not sort of any kind of a minor devaluation. There's lots of cases that say that just because a property isn't able to be used to its perhaps most valuable use, for example, in the zoning context, if zoning regulations prevent use of the land in the way that would be considered most valuable or most likely to produce income for the owner, that doesn't amount to a taking. The taking has to be a severe diminution in the value. And under Penn Central, we do not parse pieces of the real estate in order to determine that value. And we also don't parse it in terms of duration. I mean, there are a lot of cases in the zoning context where there were moratoriums on or moratoria on development that went very long periods of time. So literally the land could not be used, could not be developed, could not be used for any economic purpose. 18 months, 32 months, those periods of time were not enough to constitute a regulatory taking. So there's not a severe impact. Investment back expectations, Your Honor is absolutely right. There's an admission in the plaintiff's brief that they view Massachusetts as one of the most heavily regulated states for landlord-tenant issues. Obviously, they can't have had a reasonable expectation that in a state of emergency such as this, a pandemic, which we really haven't talked much about the facts in this case, but I just want to emphasize what is in our brief, that this is the very unusual occurrence of a major public health crisis happening at exactly the same time as a major economic crisis. Most of the cases, I think all of the cases that we cite, have to do with one or the other. For example, Jacobson is about a public health crisis in terms of the smallpox epidemic. Blaisdell, Block v. Hirsch, a lot of these cases involving property rights are about economic crises. Here today, we have both. And the idea that Ms.
Grady, doesn't that cut against your argument on investment-backed expectations? Aren't you saying, how in the world could a landlord ever have this expectation that these two crises would coalesce together? The most basic investment-based expectation a landlord has is, if somebody doesn't pay the rent, I can evict them. And the only circumstances that have prevented that from happening, you're saying, nobody could have predicted. So doesn't that suggest that this goes beyond, that the landlord should not have had this particular statute, this particular circumstance as part of their investment-based expectations?
I don't think that's true in the sense that in terms of what landowners could expect. So some of the prior cases involve economic emergencies that were not necessarily more foreseeable than what we have going on now. So I don't know that it's clear that the landlords couldn't have anticipated the possibility of some emergency that would require a situation where they couldn't regain possession. But certainly they are used to operating in a legal landscape that is heavily, heavily regulated. Like I said before, the SJC has decided that a violation of the security deposit statute could be a defense to possession. There's all sorts of defenses in 239 Section 8A to possession. So here in Massachusetts, certainly the landlords are operating in an area where they should expect regulation, and particularly regulation in the event that an emergency requires the legislature to act. Finally, moving on to the character of the regulation. This is a tailored and temporary regulation. Mr. Vetstein is saying, well, it's not as tailored as some of the other, whether they've been executive orders or pieces of legislation, in particular the New York executive order. I don't think there's really a comparative question here, just because other states might have done something where the evictions are held off only in certain circumstances that are narrower than the circumstances here. That's not really the analysis to compare what different states have done in response to this pandemic. The analysis is the character of the regulation reasonable to meet the emergency that's happening. And it plainly is. It's a tailored regulation in the sense that there is a carve out for situations where the eviction is warranted because whatever the tenant might be doing whatever violation of the lease is going on, could be a danger to the health and safety of other people. In the commercial world, it's only small business premises that are affected, not larger commercial spaces. And even the small business premises, there's a carve out for situations where the tenancy had already been terminated before the state of emergency. And it is tied temporally to the state of emergency. 45 days after the state of emergency ends, that is when that is the outlier. That is the last moment the eviction moratorium could stay in place. So it is absolutely limited in time and tied to a very specific event. And I would argue tailored to meet the needs of the Commonwealth in the face of that event.
All right. Let me go to Mr. Mikolakis and ask you about Penn Central, or if you want to comment on the physical occupation argument, you can do that too. What's your view on the takings argument?
Well, I would second what my sister says about the physical occupation or total loss or total takings prong. I think the moratorium is easily distinguishable from those scenarios, both due to what I believe Your Honor raised earlier about it's not really a posit where you're dealing with a scenario that landlords themselves invited. And I would also point out, sort of similar to the discussion about rights to petition, going back to the first year property concept of a bundle of rights or a bundle of sticks, however you want to phrase it, what the legislature here has temporarily curtailed one stick in the bundle, right? And left left all of the others untouched, which I think is, it's important to bear that in mind. I think I would also echo what my sister says about, we haven't talked much about the facts yet. And I think the facts here are really important, going to both economic impact and character, and to a lesser degree, investment-backed expectations. But, I think what plaintiffs here are really standing on is, they don't appear to be disputing the scope of the crisis that we have faced and continue to face, the intolerable and unimaginable toll of death and economic devastation that we've experienced. I also don't hear today or reading their reply, I don't think they meaningfully dispute the disgracefully racially disparate way that it's hit the Commonwealth and the nation. They don't dispute that pre-existing racial disparities, including and especially housing disparities, explain that to a large degree. I think there's a lot of really compelling materials in the amicus briefs and our brief about overcrowding, which is something that's been happening in a lot of communities where rents are spiking. Essential workers, the people who've been putting their lives on the line over the course of this crisis since March, so our society can continue to function, they can't afford to live in apartments. Average rents are more than a 40-hour per week schedule on the minimum wage, right? So what happens there? You rent a room in an apartment with another family. In some circumstances, you don't have a stable home, and it's clear the connection between that and the spread of COVID-19. And I would additionally point out that no one is really disputing that shelters, that solution, the efficacy and safety of emergency shelters, not just a Boston problem. There's a lot of compelling materials in the Coalition for the Homeless brief about the statewide crisis in emergency shelters and the fight to depopulate them to keep them safe. And finally, and I think critically, they're not disputing that, and in fact, I would say welcoming the chance that there are going to be more eviction filings once the moratorium lifts. So really, the factual dispute is, does a rise in eviction filings, an exponential rise potentially, does that actually materially increase the chance of more homelessness in the Commonwealth? And I would caution the court about not not understating the plaintiff's burden here. It's not, I wouldn't say that the court has to believe everything that we and the Commonwealth say about the facts of the crisis. What they have to believe is that there's no rational connection between the legislation and what could plausibly ensue in the absence of that legislation. So, I think my brother overstates it by a lot when he says, essentially or implies that in order to uphold this statute, you need to find definitively that there would be a tsunami. Your Honor, there are 5,000 pending cases right now in the housing court, some of which are post-judgment. Taking into account those cases alone, I think it's extremely likely that lifting the moratorium, again, only considering that aspect of things, will lead to a non-trivial increase in homelessness, and that's going to spread the disease. No one is disputing that. I could also get into plaintiff's affidavit and sort of why I believe that contrary to what they're saying, filings will in fact materially increase the risk of mass homelessness. Your Honor might want to wait until the balance of harm section to hear about that.
That's the harms argument.
I'm happy to quickly discuss the legal aspect as well, in particular the legal character of summary process. Your Honor has already pointed out in other contexts, it is a heavily regulated regime. There are tremendous hurdles to gaining possession in summary process, which are similar in character to the legislation that is discussed here. I really want to emphasize 239-8A and how it works. And in particular, the way it's described in the nurse case, it's uncannily similar to how the moratorium operates here. There, the SJC describes 8A as a time-limited equitable remedy to recovery of possession. There, the time in question is, you can't recover possession for the period of time in which you engage in unlawful acts that support a tenant's counterclaim. You can't recover possession, with respect to that time. And here, the legislature is doing something similar. They're placing a temporal boundary upon the recovery of possession. Put differently, what this is it's a legislative act that says there's no claim to possession in the midst of a global pandemic, except under circumstances that are essentially worse than becoming homeless, or worse for society than the risk of potentially increasing homelessness during a global pandemic. So I think that's really important to keep in mind too. The last thing I'll say is, we're not operating in a legal vacuum here. We talked a little bit about the New York legislation. I would point out that the Federal CARES Act, which was enacted in March, enacts a fairly similar scheme with respect to federally subsidized properties, including properties that are subsidized with a Section 8 voucher. It's similarly comprehensive in the sense that it bars the filing of new actions, and it doesn't apply to pending cases, but in terms of the idea that they're trying to put on hold any non-payment filing is similar here. And as far as I'm aware, no court has, I think there was a lawsuit in Texas regarding the CARES Act that was dismissed. Well, the TRO request was dismissed fairly promptly, but I'm not aware of any other suits challenging the legality of the CARES Act, either on takings grounds or for that matter on First Amendment grounds, since it also has some of the characteristics similar to the act in that respect as well. I will stop there if Your Honor has questions.
Thank you. Let me go back to Mr. Vetstein on this, a more general question than just on takings. Mr. Mikulik has suggested earlier on, and I think maybe the Attorney General has done this as well in her brief, that the standard here that I need to apply ultimately in deciding this case down the road will be a rational basis review of this statute. Because as Ms. Graney said earlier, there's no fundamental constitutional right involved here. Do you agree that when this case gets to the point where it's before me or somebody on summary judgment, it'll be a rational basis analysis?
No, I don't, because that comes up only in the context of due process challenge and equal protection challenges. What they're really talking about is the exercise of police powers. And that is what Jacobson, the Jacobson case was all about. We're not talking, and frankly, my brother raising, race and all that. I mean, this is a facially neutral statute. It gives a moratorium to any tenant, whether they're Black, Brown, Asian, Hispanic. So the whole notion of race being a factor in this case, it's while we appreciate the systemic issues regarding race and housing, it's really not part of the case. But we're talking about police powers here. We're not talking about rational review, and that, because that's the analysis that usually goes on with equal protection. So with the police powers, the Jacobson case.
Yeah, you're right. We're talking about police power. I appreciate that point. Jacobson applied a pretty darn deferential standard in deciding whether the police power extended far enough to permit the Commonwealth of Massachusetts to require smallpox inoculation, right? So what is the standard of review under Jacobson and under the police power in general? It's maybe we wouldn't call it rational basis, because that's a phrase, as you say, that's related to equal protection and due process.
Yeah.
But isn't it substantively similar?
Well, a couple things on that. So, with Jacobson, we're dealing with vaccines and inoculations, and so what they were talking about is more of life, liberty, and obviously a needle going into someone's arm is different than an eviction. But what they did say is that the state, and there's no question that the state has broad police powers. However, the police powers can never trump constitutional rights. So fundamental constitutional rights cannot be quarantined even during a global pandemic. And that's what Judge Stern said in the ACA case. Again, we're dealing with credit card debt. I mean, he enjoined debt regulations for credit cards. I mean, there's no fundamental constitutional right there. Here, contrary to my brother and sister, I do believe we have a constitutional fundamental right in play on the access to courts and on the property issue under the Fifth Amendment. And potentially, and we haven't talked about due process, but obviously the due process clause provides for, government can't pass a law depriving someone of property without due process of law. I mean, that's the
I understand that, but let's not go there. Those are all in federal court now by your action. And
well, yes and no. I mean, a lot of, the right to petition and access to courts, that is, I mean, the Massachusetts Constitution, as everyone knows, was passed before the U.S. Constitution, and the U.S. Constitution was modeled largely on our Declaration of Rights. So the case law that is developed under the First Amendment has been used interchangeably by the SJC. So there's a lot of overlap between the federal issues and the state. They're really quite similar.
I hear you, but I'm dealing with state constitutional claims here. I'm going to pay most attention, obviously, to judicial decisions of our courts interpreting our, as you say, pre-existing Declaration of Rights before we even had a constitution. Is there anything else you'd like to say about the takings before we move on to?
No, my brother was kind of veering into irreparable harm. So,
Attorney Vetstein, I think Judge Wilson is off. Oh, maybe he's back.
Yes, thank you. I was off there for a second. I'm back, I think.
Back on.
There, you're all appearing. Okay.
Yep.
My connection just cut out. So repeat the last 30 seconds of what you said while I was
said,
off.
No, I'll rest on our brief on the takings. I don't want to, beat it down too much. So I'd love to move to irreparable harm.
Yeah, I would too. So let me ask you the first irreparable harm question. Do you think you need to establish irreparable harm if I decide you have a likelihood of success on the merits of these three state constitutional claims?
Well, we cited the cases in our brief, and they are, federal cases, but obviously, like I said before, we're dealing with very much overlap. But there is a line of federal cases which says First Amendment cases that if it involves a First Amendment type of issue, so right to petition or right to free speech, then it's not, you don't require a particular showing of irreparable harm. So I would think that would apply, but regardless, I think we have absolutely made a showing that on balance, and I'll get into that, is that the claim to irreparable harm weighs much strongly for my clients than it does the Commonwealth. And I'd like to get into that if you please, Your Honor.
Okay,
so
you're already talking about the balancing of harms. Before we get to the balancing of harms, could you tell me what your irreparable harm is? As you know, the law of the Commonwealth of Massachusetts says you're not entitled to an injunction because you have no irreparable harm if the case is essentially about money. Why is this not a case? Why is this not a case essentially about money?
Yep, it's a case about possession of real property. So the McCarthy v. Tobin and the Davis v. Comerford line of cases saying that real estate is unique in Massachusetts, that equitable remedies are the preferred remedies. So, obviously we, even in cases involving purchase and sale disputes or boundary line disputes or zoning disputes, courts routinely grant injunctive relief in those cases because they do raise fundamental property rights, as in this case. So particularly, I'll quote the Davis Comerford case on page 180, the time lost in regaining real property from a party in illegal possession can represent an irreplaceable loss to the owner. So that says it right there.
It's not, but it's not irreplaceable if the owner can today sue for breach of contract and collect the money that he would have expected from that time in which he was in possession but not paying rent, right?
Again, but a breach of contract case in district court will not get you an execution for possession to remove the tenant. That's the problem. So again, we're talking about possessory rights as opposed to contractual rights. Someone living in it's your property. You own the property. Someone's living there without any right. Sometimes, and this be happening in our case, you have an unauthorized occupant. The tenant lets someone else into the unit that has absolutely no right to be there whatsoever. And it may not it may not constitute a criminal activity that would affect other owners, like a brother or a mother-in-law, who knows? Okay, that person has no rights in the property, and yet under the moratorium, you can't evict the person. So it absolutely is an irreparable situation with property rights.
All right, let me ask Ms. Graney about what you've just said. First of all, 2 points, Ms. Graney. First, Mr. Vestine suggests that because this is First Amendment-like, he doesn't need to prove irreparable harm anyway, but he doesn't worry about that because he says, since this is about real estate, it's not about money, and Davis versus Comerford says that it's irreplaceable if you lose your right to your property for some period of time, as he says is happening here. What do you say about both of those irreparable harm arguments?
So I disagree with both of them, Your Honor. On the First Amendment point, the plaintiffs haven't cited a case under the Declaration of Rights that suggests that they don't need to show irreparable harm. So I don't think that is correct as a matter of law. In the First Amendment right to petition context, they certainly would have to show irreparable harm. And I think that's definitely true here as well. So I don't know of any case law that would take them out of the irreparable harm showing in order to try to get an injunction. On the point about real estate being unique, those cases, McCarthy v. Tobin stands for the idea that real estate is unique and therefore a buyer can get specific performance as a remedy. I think the only argument that could go to in the plaintiff's three arguments is really takings. And it isn't just because we do have case law that says real estate is unique, and as between a buyer and a seller, it's possible to get specific performance, doesn't negate the whole law of eminent domain, which is that the state, reserves rights to take property. And precisely because it is unique, the state might want to take a particular property because it has particular features that the state needs. So to sort of try to bring the McCarthy v. Tobin unique property standard in on the takings theory doesn't quite make sense. So I don't think that the fact that property is unique negates the need for irreparable harm. Clearly, I don't think there is irreparable harm here. Your Honor is correct that this is a case about economic harm and monetary damages. The damages that the plaintiffs repeatedly recite are the failure to be able to recover the rent that they're entitled to. There certainly is no irreparable harm there. If Your Honor would want me to go to the balancing, I'd be happy to. I could move on to that.
Yeah, before you do that, let me go back and ask Mr. Vetstein, before we get to the balancing, have you made the points you want to make about what the irreparable harm is, this loss of, for some period of time, of the ability to get a tenant out who is not paying rent or is there otherwise illegally?
Well, it's not. I'd say it's not just about, again, my sister keeps saying it's about the money. It's actually not about the rent. It's about possession. And it's just not non-payment. It's also all these other types of cases where you have people who have no right to possess the property who are possessing the property, and there's no way out for the landlord to get these folks out of there. But even if we are talking about economic harm, the economic harm is potentially devastating for my clients and for many of the small landlords and mom and pop landlords around the state, because again, the fatal flaw with the act is it doesn't provide any rental assistance funding. So when you're talking a tenant who doesn't pay, then all that burden trickles down. And because of the lack of equities with the foreclosure relief, a lot of landlords who either don't have mortgages or have straight investment mortgages, they don't get any foreclosure relief. So they are facing, $20,000, $25,000 in rental losses, and they can't afford to pay the mortgage, the mortgages on their house or the real estate taxes or the property expenses, insurance, repairs. Another inequity here is that while summary process cases are closed, code enforcement cases are specifically open. So a tenant can actually go into court, court's open for them to file for code violations, and the housing court has authority to fine and, call criminal actions against landlords for not making repairs or sanitary code violations. So,
all right, well, I think we're getting into the balancing of harms here, and that's where we should go next. So why don't you I'll explicitly ask you why you think the harm to your clients, who say in their affidavits, by the way, that they will struggle, future tense verb struggle, if they don't get the rent, they will struggle to make the payments they need to make to whoever, maybe in one case a mortgagee, and of course utilities and things like that. What they say in their affidavits didn't strike me as a very powerful harm to them. And I'm not downplaying the harm that the people who are in front of me are suffering here. But it didn't sound to me like it was something that should necessarily outweigh the harms on the other side here to the state, to the citizens of the state for whom the legislature enacted this particular piece of its various COVID relief legislation.
So, Your Honor, if I may, I'm going to start from the backside on this one. I'm going I'm going to tell you why there's very little, if any, irreparable harm to the state and tenants, and then I'll get to my clients. So the narrative that we've been getting all along is this notion that there's going to be a tsunami of evictions if the act is lifted. And that in turn results in a massive amount of homelessness and then a massive amount of COVID infection. So
can I guys stop you there? I don't see that. I don't think that's the issue in front of me. I started to say this to Mr. Mikulakis, but decided not to. I don't see the issue before me as what would happen if I enjoin enforcement of the statute. I see the issue before me as whether the legislature did something unconstitutional when it enacted it in the first place. That's really the issue here, I think, isn't it?
Well, I mean, the state and the interveners are making that argument on balance of harms. They're saying that if the moratorium isn't in place, Your Honor, look at all the harm that we're going to be suffering compared to the plaintiffs. The plaintiffs are only out money, but we're going to be put on the street. So that's the argument that they're making.
You're right, and so maybe I should have asked Mr. Mikulakis that question, and I will in a minute.
Yeah.
But I think it affects how you do the balance of harms analysis. It's not comparing the harm to your clients to the harm that would arise if tomorrow there were no moratorium in place because I enjoined it. It's balancing the harms to your clients against the harms that the legislature thought it was dealing with when it enacted the statute and the governor signed it back in April. So that's the analysis the balance I'd like to go through if you could.
Well, I think it's kind of the same issue. I mean, if what the state is saying, the AG is saying, although there's no legislative history or declaration or report or anything, but what they're saying is that this law was passed to address a housing crisis that was accelerated by the COVID pandemic, which, and as my sister incorrectly states, it's the COVID crisis caused the economic crisis. And we've all been watching stock market, and there's a direct correlation between that. Unlike, that's why this is so unpredictable. We don't know if if it's a vaccine, we could see the stock market shoot back up again, but that's another story. But so what they were, I think, trying to do, although it's kind of unclear, is to me it's an economic stability type of legislation. It's purely geared towards the financial harm, because there's no, if they truly they cared about public health, there would be provisions dealing with social distancing in housing court, or video conferencing, or stuff to minimize actual COVID transmission within the courts. But all this says is you can't bring an eviction because we think that evictions are bad during COVID because people will be out in the street and then they'll wind up in a homeless shelter, and then they're going to spread COVID amongst the homeless population, and they're going to spread it everywhere else. And you can obviously ask my brother and sister, but I think that's the essence of their irreparable harm argument. And what we've said all along, we filed Attorney Ward's affidavit, who's probably one of the, if not the top, or one of the top landlord tenant attorneys in the entire state, is that's if tomorrow, today, you decide I'm going to enjoin the act, what's going to happen tomorrow? Absolutely nothing. Absolutely nothing. What's going to happen in a week from now? Nothing. A month from now? Maybe a little bit of something, but it's going to take the housing court so long to process their existing caseload. And we know this because Attorney Ward has spoken to the court personnel. And we also know this because we've participated on Zoom calls, and given their published COVID-19 related safety protocols, eliminating the Thursday pack call of the list, which, as you might know, every Thursday, and you go to Boston Housing Court, and it's a crazy scene. There's people everywhere, and there's 200 cases to be called on the list. That's not happening anymore, and it will not happen for the foreseeable future. So for the days of a packed housing court with people are over. They are over, and they won't be back for many years. And that's exactly what the court personnel said. So we're moving to a new normal with Zoom and with other types of technology that it's going to move cases, but they're going to be moving slower than a snail. So whereas in the pre-COVID, it took 6 to 12 months to get a jury trial in housing court, it's going to take 12 to 18 months. And the court has said they're going to give preference to cases that are already filed. The executions are now stale. They're over 3 months old. They're requiring lawyers to come back into court and make a motion to restore an execution and get a new one. It's going to take months and months. It's going to be literally not until the fall or towards the winter where there's going to be any semblance of a normal processing. So this whole notion that the amici and everyone else, that the only submission, the only piece of evidence that you have on this issue is Mr. Ward's affidavit, which I submit as a very trustworthy opinion, and then the affidavit of Colin Harnsworth, who doesn't even address all the COVID safety protocols. And really, he mostly talks about how it used to be pre-COVID with the packed courts. But, again, we have Housing Court Standing Order 5.20, which says, no, the days of packed courthouses, those are long gone. It's going to be a new normal. So if we take away kind of the bottom piece of the Jenga puzzle, that there's not going to be a tsunami of evictions anytime soon, certainly not within the next couple months, certainly not tomorrow, not a week from now, and probably not 2 or 3 weeks from now. If we pull out those Jenga pieces, the entire puzzle falls down, and there's not going to be an increase in homelessness. There's not going to be an increase of COVID. Not to mention the fact that we all see the Mass Department of Public Health, daily charts on COVID. And there's just an article, and we cited in the reply brief, and thankfully Massachusetts is, if not number one, but the top 5 states in terms of how we are dealing with COVID. And so, we're doing well. So this pandemic, and obviously we have to be careful, but this pandemic is now moving towards the later stages, and it's time to open our courts back up. And there is a way to do this. So if there's concern that, if the act is struck down or it gets reactivated, rest assured that the housing court has the protocols in place to deal with evictions in a slow and deliberate manner. And same with the attorneys. Landlord attorneys, we're not in the business of putting people on the street. And as Attorney Ward said in his affidavit, the cases of an actual forced move out order are exceedingly rare. He's practicing for 40 years. And he said that I can recall the number of times I had to actually do a forced move out, on 1 or 2 hands. And he said that he doesn't recall any instance where a tenant was rendered homeless because of an eviction. And usually in these negotiated agreements, the landlords provide rent concessions, or we do what's called a cash for keys, or and there's also obviously advocates there for the tenants, and there could be raft, funding, or there could be Section 8. So again, the problem with the act is it took all the alternative dispute resolution away. So during this entire time, we could have been working on cases and solutions for potential homelessness that would not result in homelessness and increased COVID infection. But the legislature thought that they, essentially overruled how the courts would handle it.
Let me actually ask you about what the legislature thought. You didn't cite to me a whole lot of legislative history here. And I hear from Mr. Vetstein's brief that this happened awfully quickly, and while legislators were remote. And so how do we know, when we're doing the balancing of the harms analysis, how do we know what harms the legislature was aiming at here? Mr. Vetstein says this was all entirely economic, not about a healthcare crisis at all. Is there proof to the contrary?
Is that directed to me, Your Honor?
Yes.
You cut out in the beginning. Okay.
Yeah.
So I don't believe that the court needs to determine exactly what motivated the legislation. I think all that is necessary is that there is all that's necessary to sustain the legislation in terms of sort of that due process question is that there is, of course, a state interest that's legitimate. In terms of the harm and balancing the harm, I don't think what may have been in any particular legislator's opinions about whether this was necessary or why this is necessary is anything that the court has to probe. I think the Commonwealth can suggest, based on evidence that we put in the record, that in fact there would be a very severe harm to the public if the moratorium were to be enjoined. And some of the evidence has to do with crowded housing. The single biggest factor, and this is in the Melnick affidavit, the single biggest correlative factor in the towns that have the highest incidence of COVID-19 is not necessarily density of population, but the crowded nature of the housing. So more people than there are rooms in a house. Where you have crowded housing conditions, you have inordinately high rates of COVID-19. Mr. Vetstein's papers do talk about the fact that many, many tenants move out before they are forced to by levying on an execution. So the act of lifting the moratorium and allowing tenancies to be terminated, allowing judgments to be entered in existing cases, allowing executions to be issued in existing cases, all clearly would be likely to result in more people being displaced from their homes. The fact that they might not wait until the sheriff is at the door to actually leave is not really dispositive. The point is that people are being displaced, and it's certainly reasonable to suggest that if those people end up in more crowded living conditions, they will be at higher risk of COVID-19. And tying that back to the public health issue, we have ample evidence in our affidavits that every new infection of COVID-19 is significant. And that's in the Baracus affidavit. He says every new infection increases the risk to the public as a whole. The Burrell affidavit speaks to each person who avoids developing COVID-19, prevents the contacts that they have, their family members, frontline workers that they come into contact with from potentially contracting COVID-19. So each individual infection actually matters. And even if there won't be as many people displaced as someone like Tim Reardon, that's one of our affiants on the economic piece, and he speaks to how many households are already behind on rent and have missed rent in April and June as an indicator of the massive number of people that would be facing eviction if the moratorium is lifted. Even if the numbers are not as high as predicted by someone like Mr. Reardon, doesn't mean that there isn't a truly significant public harm here. And I do think the core point that Your Honor made at first, and this really, I think, goes just as much to the substance of whether there's a likelihood on the merits as it does to the irreparable harm, is that in a situation like this, where the legislature has acted in order to address an emergency, it really is up to the legislature's judgment how much risk it is willing to take. And this court doesn't have to decide whether this act actually was necessary as a matter of fact. The court doesn't need to decide that. That is really the legislature's judgment. And there's certainly ample evidence. When you look at the curve of where COVID-19 was on the day the moratorium went into effect, and I believe this is shown in our affidavits, it hadn't actually peaked yet. So our trajectory was still going up at that time. So, Your Honor, there clearly is a significant risk of harm to the public of enjoining the act, and absolutely the balancing favors denial of the motion for preliminary injunction.
All right, let me go on to Mr. Mikolakis on this topic as well. You've focused quite a bit actually on the balancing of the harms, I think, but I'll give you a few minutes to tell me your view on this question.
Sure, Your Honor. And if I may, I just want to clarify my sense of the legal standard here, because you raised the point about whether or not we're analyzing what happens tomorrow if you enjoin the statute versus what was the legislature's judgment at the time. I think you can consider what will happen tomorrow if the act's enjoined, simply because the PI standard is, you know, the balance of harms in terms of maintaining the status quo versus upsetting that status quo in light of the chance of success on the merits. I agree with Your Honor that, you know, the legislature's judgment at the time is also relevant to that determination, because I think that goes to success on the merits, right? And balancing that with the harms that in your judgment you think would ensue tomorrow. So I think you can consider both. And the other preliminary legal point I would make is that, again, I agree with my sister about what the legal standard is with respect to the legislature's judgment at the time. You do not have to agree with every single factual point, or even mostly agree with our conception of the facts. You simply have to find that it was not unreasonable or implausible. And I simply don't think plaintiffs can come close to meeting that bar. As you noted, Your Honor, I've already talked about some facts or some factual pictures that are relevant to this consideration. I will not repeat those. So I'll focus, I think, in particular upon that dispute about will arise in eviction filings, which again, I don't think anyone is disputing is going to happen, materially increase the risk of homelessness. And as a threshold matter, my apologies. As a threshold matter, I disagree with my brother that the only evidence that you can consider on that point is essentially the respective word of two lawyers. I don't think that's all that there is in the record on this piece. And for the record, Colin Harnsgate is in housing court every week, has been there every week for the past 4 years. He was at my office before then. So, I mean, he's probably been in housing court 500 times. So I do personally place weight on what he has to say and his observations. Again, I don't think Your Honor really even has to get into the point of deciding who's more credible between Attorney Ward and Attorney Harnsgate. There's plenty of evidence in the record, both in the AG affidavits and in our briefs and other amicus briefs, about the connection between evictions, even the filing of an eviction, and homelessness. In addition to the point that I raised earlier about how the filing of a case materially impacts housing search prospects later on, and therefore increases the likelihood that if you sign an agreement, you're not going to be able to find a new home at the end of it. I would point you to, there's research in the Mass Coalition for the Homeless brief about evictions as a primary driver of homelessness. There was a survey from 2011 of tenants in homeless shelters. 45%, I believe, it's either 40 or 45, cited evictions as one of the primary drivers of the fact that they were street homeless. I would point you to Dominique Williams, the director of City of Boston's Office of Housing Stability, her affidavit, which speaks to the fact that executions for possession, which is the document that allows you to move a tenant out at the end of the case, issue in 40% of all cases. I would point you to the Ajardi case, Ajardi versus Central Division of the Housing Court Department, which discusses some of the bigger picture trends of what litigation in housing court looks like for the vast majority of tenants. The big picture, which I understand is not the picture of what housing court looks like that plaintiff's affiant paints, but the big picture is that the typical housing court case is one that moves quickly. There's research that points at the median duration from filing to disposition is about 2 weeks. I'll note that that's not only tenant side research. Mass Landlords, one of the amici in this case, did a study where they observed in a cross section of filings in certain courts, median case length was, again, between 14 to 18 days, depending on how you sort of parsed out different sections of the data. And the typical case is also one in which the landlord wins. And there are many structural reasons for that. If you look at what research says, 92%, over 90% of tenants are unrepresented, 70% of landlords are. The overwhelming, as I said, every study that's looked into it, 90% and above of dispositions are for the landlord, whether it be by agreement, by default, or after trial. 25% of dispositions are defaults. So I think, the idea that lifting the moratorium would not lead to any increase in homelessness, as plaintiffs appear to be alleging, it's fanciful in my view. I just think in light of that backdrop, I would also point out a couple of legal points. First, I think there's this other overall impression from the affidavit that it's frequent for tenants to essentially draw cases out, frivolously, or when ultimately they're going to lose using legal rules. The housing court has tools in place to address that situation and ensure that even cases with jury demands, move very quickly by entry of a rent escrow order. The Commonwealth case that was cited earlier in the irreparable harm discussion stands for that proposition. A non-paying tenant simply cannot draw cases out as long as that affidavit appears to be suggesting. The other legal point I wanted to make sure Your Honor knows is that there is no defense at common law by statute to possession based on hardship or inability to pay. Nothing. Moreover, because this provision was cited in the affidavit sort of as a counterweight to the notion that filings will increase homelessness, the stay provisions, 239(9) and 10, only apply in no-fault cases. So if a non-paying tenant is ordered evicted, judgment for possession, which again can happen, tends to happen within 14 days of filing, they can't argue on the basis of that statute that they should get more time. I mean, as a practical matter, many tenants often do, but my experience is that in those contexts, if the judge grants relief as a matter of equity, it's typically very short, and it's typically connected to factors like, well, the truck is coming in 2 days. Can you pay the truck fee, which is anywhere from $300 to $1,000, depending on when the move out is scheduled for. So I don't think it's the case that the courts have the legal tools to as a matter of equity, ensure that this wave of tenants who are behind on their rent will not ultimately be displaced. And the last point I'll make, because I think it connects to a theme that plaintiffs' counsel in particular has been raising here about money, about funding. I think the undertone of plaintiffs' argument is the legislature shouldn't have done this. They should have enacted funding. The legislature has done that. In
fact, when he mentioned the RAFT program, I recall that in your brief or the brief of one of the other amicis, there's $20 million more in that RAFT program that just happened in the last couple of weeks.
Last Friday, Your Honor.
Right.
Last Friday. And in addition, so a couple of other recent developments. There's a new program called IRMA, Emergency Rental Assistance Massachusetts, I think is what it stands for, that is available for folks who are above the RAFT cutoff. That was done administratively. RAFT applies, I believe, up to 50% of the area median income. IRMA goes up to 80, capturing a much broader cross-section, potentially, of the non-paying tenant population. And then in addition to what Your Honor mentioned about the additional money, the legislature also raised the cap of funds that can be received from $4,000 per household to $10,000 per household, which is obviously going to go a long way towards potentially saving individual tenancies. And then cities and towns across the Commonwealth, the CHAPA brief, the CHAPA, MACDC, and Mass Public Health Association brief talks about the 40 cities and towns that have enacted their own programs using a variety of federal, state, and local funding sources. So, I mean, the upshot here is that there is money available, but what is needed is time, right? Tenants and landlords, for that matter, need time to get the money. Cities and towns need and the state for that matter, needed the time to enact new programs that are more responsive to the current moment and make them a reality. What gave them that time is the eviction moratorium. So, you know, as has been stated, you know, by the AG, we're not out of the woods yet. So in terms of, you know, ensuring that the kind of outcome plaintiffs want, which is to be made whole, can actually happen, we do need that breathing space. I think
let me cut you off there. There's one more issue I need to decide in an injunction analysis in which there is a state agency that's a defendant. It is how the public interest plays into the injunction decision. I think, frankly, we've already covered that because it's very closely tied in with the things we've been talking about. So I don't see a need to have a separate debate on that topic. But if council think differently, I'd be willing to hear why you think we haven't already covered it.
Well, I'd like to address some of the issues that my brother raised, which go into public interest.
All right.
If I may. So, I mean, Mr. Lakos is a great advocate. However, everything he said is pretty much inadmissible. He's, you know, citing to studies and extraneous materials they're not part of this record. They were not attached to any of the affidavits. Interestingly, they had the opportunity as enhanced amicus, but there's not one affidavit from a tenant, an individual tenant, about how they are impacted, which I found to be just incredibly surprising. And it's really kind of a black hole in the factual record here. So there's a lot of hearsay in the affidavits. I mean, I didn't move to strike because I think it's a question of, you know, giving the weight to the evidence. And even in the affidavits that the AG submitted, you know, no one's, I mean, we're not disputing that COVID it's obviously a public health crisis. We're not disputing that the transmission rates or any of the epidemiological information or the medical information. What we're disputing is this notion they have to, in order to get from A to C, they have to establish A, which is the you know, market increase of not just eviction filings, it's actual forced move outs. And so when they cite a study that says, oh, there's an execution for possession has been issued, well, as Mr. Ward says in his affidavit, they're issued routinely in all sorts of cases, and they're issued routinely in cases where there's been negotiated agreements. So if you go to housing court and you do an agreement for judgment, it says judgment enters for the plaintiff for, you know, $0 and execution shall issue on or about this date, and it's tied to the move out date, which is an agreed upon move out date. So the fact that there's been executions issued does not necessarily correlate to the fact that there's been forced move outs by sheriffs, which, mind you, costs many thousands of dollars because landlords are required to pay 3 months of storage in advance and moving costs. So again, they are exceedingly rare, and we're the only ones who've addressed that with admissible evidence on our side. I'd also like to point out, you know, the issue with, you know, RAFT and all those programs. Typically, for those programs, there needs to be a pending eviction, and typically the applicant will give the government, the agency, here's a copy of my eviction notice or my eviction case, and here's a copy of my agreement, and then I get the money that way. Same thing, you know, with some of the federal programs. So, but the argument that there's funding available cuts against the plaintiff's argument. I mean, so the defendant's argument that there's irreparable harm. But there's more funding available for, you know, homelessness, then, you know, that's good. And then that would cut against them in terms of their irreparable harm. But the money doesn't go to the landlords. You know, it'll go to the tenants, and there's, you know, sometimes that money doesn't get put towards what it's supposed to get put towards. So there's that.
That's wrong.
You don't need to, Mr. Michaelegis. I'm not. We are now certainly venturing into the realm of speculation about a lot of things, which I don't think will play a decision.
I do just want to correct the two misstatements that were just made. First, that a notice of eviction or a notice to quit is required to get RAF funding. That requirement was waived in light of COVID. And then second, the money never touches the tenant's hands. It goes right to the landlord. That's how it works. That's all I'll say.
All right. Any final thoughts, Mr. Betstein, before we go have lunch?
I just will point to the, I said it in the brief that goes back to 1807. The Circuit Chief Judge Cranch is we have to remember that the Constitution was made for times of commotion, and again, just because we're in a global pandemic doesn't mean that your constitutional rights are suspended or quarantined. In fact, it's these type of situations where it's all the more important that we have checks and balances, and we have judges and we have courts to tell us what the Constitution says, and that's what we're asking you to do, Your Honor. And I don't envy your job. It's a hard case, and it's a novel case, and it's a case of first impression. So we're all kind of dealing with uncharted territory here, but I think we've given you the roadmap. That again, I could go back to it just goes too far. It's the nuclear option when they could have used a scalpel and an incision. They bomb the whole thing, and that's what tips it over the edge.
All right, Ms. Graney, a 1 minute
Yes.
last word from you as well, if you want.
Yes, thank you, Your Honor. What's before the court right now doesn't require the court to second guess the judgment of the legislature as to whether this was a wise policy choice. All that is before the court is whether the plaintiffs have shown the PI standard, number one, a likelihood of success on the merits. On all three of their constitutional claims, Article 30, Article 11 and 29, right of access and takings, they have not shown a likelihood of success on the merits. So the court can simply stop there. If the court reaches irreparable harm, balancing public interest, the plaintiffs have not shown irreparable harm. Obviously, the balancing means that it tips towards the defendant's side, and the lack of, there is a sliding scale related to the lack of likelihood of success. So the less likely the success, the more harm one has to show. Clearly that balancing favors the Commonwealth and EOHED here. And then finally, the public harm that would result from enjoining the act far outweighs, and our 15 affidavits, I think, show that far outweighs the potential harm to the plaintiffs of Your Honor denying the motion. So the motion for preliminary injunction must be denied.
All right, Mr. Mikolakis, your 1 minute of last word, if you'd like it.
I think I'll do it in less than a minute. I will only add to what my sister said by saying that the factual record before the court, including affidavits, as well as the research presented in the various amicus briefs, I think points uniformly toward a conclusion that lifting the moratorium would lead to displacement, and that in light of that, and in light of the harms that the legislature sought to address at the time it enacted the statute, and in tandem with the legal characteristics of the moratorium, which mirror what's in existing law, in existing summary process law, ultimately should lead you to conclude that it's constitutionally appropriate in all respects. Thank you for your time.
Well, thank you all. I would like to thank all three of you. As Mr. Betstein said, this is a difficult case. It is a case, it's of first impression. This is not the sort of thing that comes up every day in the Superior Court or in many courts, I suspect. And hearing from you at such length has helped me understand better the positions of the people you represent. And I do appreciate your help. I'm going to take the matter under advisement. I'll issue a decision as soon as I can and just leave it at that. So thank you all very much.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you, Your Honor.
Crafting the introduction of a song with a memorable guitar part is a difficult